Good morning, everyone. Thank you for joining us in today's iTOO session. I'm Lucia Swartz-Horn, Senior Claims Specialist in the iTOO Claims Department. I'm joined today by Erin Keynes. She's a Senior Associate at Clyde & Co., who does work for the Joburg and Johannesburg offices. Erin has experience in all aspects of insurance law with particular interest in medical malpractice, professional indemnity, product liability, personal injury, and construction law. Erin not only specializes in litigation and alternative dispute resolution, but she also advises insurers on policy response and cover disputes. Welcome to you, Erin. Thank you for joining us this morning.
Thank you very much, Lucia.
So today's topic is centered around civil and criminal liability of healthcare professionals. The idea of the topic came about when a workshop I signed up for unfortunately got cancelled. So the topic it was of great interest to me, and so I thought it would make a captivating subject for an iTOOsday session. I'm just going to quickly share my screen just to highlight some of the topics we will be touching on this morning in the session. So what we will touch on this morning, our key focus areas will be on what constitutes medical negligence, who regulates the healthcare professional, what is a healthcare professional's responsibility in practice, what are the patient's responsibilities, how are medical practitioners held accountable, the onus and burden of proof in the different elements of liability, civil versus criminal liability, as well as the causation aspect. We'll also look at a few common scenarios leading to civil and criminal liability. Very importantly, we'll touch on the role of the HPCSA. We'll also look at international trends centered around the topic. We'll have a look at the South African Medical Association's position on the criminalization of medical mistakes, errors, and gross negligence. We'll also have a look at some interesting case studies this morning, and then we'll end off with our concluding remarks. So this morning, we don't have a formal presentation prepared, but Erin and I will be in conversation to touch on the topics, the key areas I've now just pointed out to the audience. So claims for medical compensation in South Africa has been on the rise since 2007. Recently, however, it seems that there's a heightened awareness of criminal charges made against healthcare professionals for alleged medical errors. One such case is that of Dr. Danny van der Walt. He was convicted of culpable homicide and sentenced to 5 years imprisonment. He served 8 months of the sentence, where he was later released on parole. Remarkably, the Constitutional Court has since overturned his conviction on the basis that his right to a fair trial had been infringed. The charges against another doctor, Dr. Avindra Dayanand, are also very interesting, as it seems that this is one of the first cases where the MPAA charged a doctor with murder as opposed to the more common charge of culpable homicide. Dr. Dayanand was arrested in 2022 and charged with murder following the death of a patient after gallbladder surgery. It seems, however, that the charges were withdrawn in 2024. Of course, I'm sure that we're now all aware about the Dr. Bill matter, which is it's been very publicized in the media. We will deal with this matter a little more later in detail, but Dr. Bill was charged with 3 counts of murder and 2 counts of fraud. He has since been acquitted of all charges, but these cases have raised questions about how the medical profession is regulated in South Africa. Is the regulation effective in preventing harm? And how are medical practitioners held accountable for harm? And what are the consequences that they are faced with? We have several key topics I've just shared with you that we will be discussing in today's section, including a deeper look into the role of the HPCSA and what the medical fraternity is trying to do in response to the latest string of charges against healthcare practitioners or professionals. So Erin, moving on over to you. And before we deal with these issues on a more practical level, perhaps you can just give us a brief explanation of what medical malpractice entails.
Thank you, Lucia. So medical malpractice is the body of law that deals with the question of whether a healthcare professional can be held liable for an act that they committed when or during the treatment of a patient. Medical negligence is sometimes colloquially used to refer to medical malpractice, but I think it's very important for us to differentiate between these two concepts. And particularly, Lucia, as you've just mentioned, given this heightened awareness that healthcare providers are at a very real risk of being exposed, not only on a civil basis, but also on a criminal basis. So medical negligence will occur when a practitioner's conduct falls below the standard of what is expected of a reasonable practitioner under those circumstances. And examples of negligence in this type of setting would include misdiagnosing a patient, or performing a surgery that wasn't necessarily indicated, or even performing that surgery with a lack of skill that's necessary of that practitioner in those circumstances. On the other hand, wrongful acts by healthcare practitioners that can be regarded as being intentional and then still covered under medical malpractice would be, for example, breaching confidentiality or committing fraud. An example of fraud is, I mean, you've now mentioned the Dr. Beale matter where they alleged that he misrepresented test results. Another one would be where, example, doctors are charging medical aids for procedures that haven't necessarily been performed. If the medical professional is found liable for medical malpractice, the consequences can be very severe. And as we'll see, on a civil basis, it can be through the award of a high damages claim, and now obviously on a criminal basis through conviction of, for example, culpable homicide.
Thanks, Erin. You've now mentioned by way of an example that doctors are charging medical aid funds during procedures. We've actually seen a lot of claims of this nature on our desk from an insurer point of view. So yeah, also quite interesting. And then, sorry, I just forgot to mention any questions and answers, or comments that the audience may have, please feel free to post it in our Q&A box and we'll address it at the end of the session. So, Erin, I do agree with you that it's quite important to understand the concepts and the consequences that can be faced. Of course, medical professionals are also placed in situations daily where they need to make decisions based on their training and their own intuition. They are human after all, and they can make mistakes. So not all errors are necessarily negligent though. Does this then mean that patients won't complain when they feel that their doctor has erred? Or how is the medical profession regulated outside of the courtroom?
Yes, Lucia, I completely agree. Not every error is going to lead to civil or criminal liability, but that doesn't mean that healthcare practitioners aren't still at risk of, for example, facing disciplinary charges. So healthcare professionals must be registered with the Health Professions Act, with the Health Professions Council, which is in terms of our Health Professions Act. The council is the HPCSA. And it's been established to regulate and control the education and training of healthcare practitioners, but also to ensure that professionals maintain a certain level of profession and a certain level of ethical standards. So the HPCSA will then investigate complaints that it receives against its members, and if necessary, it will then take disciplinary action. I'm referring to the HPCSA as a statutory body, and so it needs to follow the framework that's governed in terms of the Act. There's a number of other acts, obviously, that regulate the medical profession, and some of these acts then also have their own regulatory bodies. For example, the Nursing Council, which would be in terms of our Nursing Act. But the point here is that these bodies have been established to deal with the profession outside of the courts, but also parallel to the court process.
Thanks, Erin. Before we do carry on with the healthcare professionals, I do myself often wonder what the role the patients themselves should be playing in these situations. We often forget what the patient's own responsibilities are and tend to place more focus on those of the healthcare professional. Can you perhaps shed a little bit of more light on this aspect for us?
Of course. I mean, there's certainly instances where a patient's own responsibilities have to be taken into account. and how we need to see how their choices would impact on their own health status. So, for example, a doctor cannot be held liable, surely, where a patient deliberately refuses to follow the treatment plan, or, for example, if a doctor says that they must be admitted and they refuse to then be admitted. So patients have their own responsibilities, including, for example, a complete disclosure of information to their healthcare provider. It can't be expected of a doctor to know a patient's full history without that information being told. And there's obviously pertinent information that a doctor needs to know. For example, if you're a smoker and how many times you smoke, or if you take chronic medication and whether you've actually taken that medication that morning. Another thing that I think is very important to consider is the choices and the religious beliefs of patients. Often it's a controversial topic, but a family can't hold a doctor liable for the death of a patient if that patient refused to take a necessary life-saving procedure, such as, for example, a blood transfusion or any other reasons for religious beliefs.
Thanks, Erin. I'm sure there's a whole topic that we can dedicate to the responsibilities of the patient. But let's get into the crux of today's session. You mentioned that a doctor can be held liable on a civil and a criminal basis. So let's perhaps delve into these concepts, starting with the more well-known ones. I think most of us do have a good understanding or basis of your civil claims, but we don't have that in-depth insight. Tell us about the risk faced in civil claims and what impact this has on the medical professionals.
Yes, thanks, Lucia. Let's get into it. So, starting with our civil side of things, there's basically 3 grounds of liability that we'll always look at, and the first is that a practitioner can be held liable for a breach of contract. The other one will be through delict. So that would be where a patient would allege that a doctor has breached a legal duty. And then the other one is if they've breached any of their statutory regulations. And then in that regard, they would be found liable under the HPCSA for unprofessional or improper conduct. Often we find that a plaintiff will sue a doctor for breach of contract and then in the alternative sue on the delictual basis, so that they've breached a legal duty. The contractual claim will stem from the patient-doctor relationship that is created when the doctor chooses to treat that patient. I think it's important to note, though, that it's not necessarily going to be the case where there'll always be a written contract. So, for example, where an ER doctor treats a patient under emergency circumstances, then a patient can still rely in those circumstances on an oral contract. But what will often happen, and as we see is in our liability matters, is that the patient will claim that there's been a breach of a legal duty and that duty stemmed from the patient-doctor relationship that was created when that doctor chose to treat them. So often these 2 claims will go hand in hand, but the question here is whether or not that doctor was negligent. So to be able to establish liability on the part of the doctor in civil claims, we need to know whether or not that doctor was negligent, and if so, whether that negligence caused the harm that is alleged to have been suffered by the patient. So in these matters, I often find the elements of negligence and causation are the most fascinating ones. And we must always remember that even if the doctor was negligent, it doesn't automatically flow that he's also liable for the loss. The plaintiff will have to prove that the negligence actually caused the harm that was suffered. So
that's where the causation element comes in.
Exactly, yes. So just to touch on these 2 concepts very briefly, to determine negligence, we look at the doctor's conduct and we examine that compared to how a reasonable doctor would act in those circumstances. So it is a slightly higher threshold than what we're used to for our normal, ordinary, reasonable person test. But it's also not an elevated standard to the point that we expect doctors to be the most amazing doctors in this regard, and the most skillful or anything. We're looking at the reasonable doctor at that level of expertise and in those circumstances. So if we're dealing with, for example, a general practitioner, we're going to compare to how the reasonable GP would have acted in those circumstances. If we're looking, on the other hand, at, for example, a neurosurgeon, we're going to look at how did the reasonable neurosurgeon act, or how would they have acted, under those circumstances. If then the doctor's conduct does fall short of what we believe the reasonable doctor would have done in those circumstances, then ultimately it's probable that our doctor is going to be found negligent. But as you also mentioned before, doctors do make mistakes. And not every negligent error is going to result in liability. We need to then take that next step into, as you mentioned earlier as well, the elements of causation. And often causation is actually the most controversial topic. And I think that's also because it's very difficult for somebody, especially people like your patients who are not doctors and who are not lawyers, to try and fathom that, but my doctor was negligent but wasn't actually found liable. So it is a little balancing act that we need to deal with there. But ultimately, if a patient wants to claim damages, they need to be able to prove that element of causation as well. And then just to quickly touch on the damages themselves, once we've done the trial of liability and we've seen, okay, this doctor is negligent and he definitely caused the harm that's being suffered, we then still need to take that next step and look at what harm has actually been suffered and what damages can we get from that harm that's been suffered. So, I mean, plaintiffs often claim exceptionally high damages, often far into the millions. But I think the important thing here to remember is that the plaintiff will have to still prove those damages, So they can allege, for example, that they've lost millions in future income because they were going to be the next Elon Musk.
Which is always the case.
Exactly. But they'll need to prove that. They can allege that they need to move to somewhere along the coast where the air is a lot fresher and it's better for their lungs. But again, they need to give us the facts and they need to give us the expert evidence that will allow us to see that that is in fact what they need and what is warranted in those circumstances.
That's so true. And I suppose that the courts will also then need to consider what's reasonable at the end of the day, right?
Yes, exactly.
So, Erin, whilst we are still on the topic of civil liability, you did mention earlier that there can be a parallel process of disciplinary actions and that this isn't regulated by the courts. So, are you then saying that there's a difference between what we will need to prove during disciplinary proceedings?
Yes. So I referred to the HPCSA earlier as the regulatory body for members that are registered in terms of the Health Professions Act. And as I said, the HPCSA is there to investigate complaints that have been laid against the practitioner. So it will take disciplinary action where that conduct has been considered unethical or improper. And this can mean that a doctor can be found guilty of unprofessional conduct in terms of the act, even if it's not necessarily true that they're found liable on a delictual basis. And this is because we've got different factors that we need to consider when proving each of the charges. Factors that will be considered in terms of the act with the HPCSA, and then obviously our elements of delict will be on a completely different level. In fact, there was a matter where the SCA had to decide whether or not certain conduct by a member could be regarded as improper in terms of the act, even where the facts in that matter were based completely on matters irrelevant to the health profession itself. So in this matter, Dr. Grieve was charged by the HPCSA with unprofessional conduct after it was discovered that he had been trying to convince his patients to invest in a company where he was a director, but he knew that this company was in financial distress. The HPCSA then found him guilty of unprofessional conduct, and after various appeals, the matter then landed up in the SCA. And the SCA ultimately found that the definition of unprofessional conduct is actually very wide. And provided the HPCSA can show that a doctor's conduct was improper or disgraceful or unworthy of the profession, it can then institute disciplinary proceedings against its member, irrespective of whether there's actually a doctor-patient relationship in those sets of facts.
Very interesting.
Exactly, and I think it's also important to note that regulatory bodies don't have to wait for outcomes of the High Court before they themselves make decisions in respect of their disciplinary action. The HPCSA has a duty at the end of the day, and it needs to act against conduct that they deem to be unprofessional. So, in fact, in the Grieve matter, the court specifically noted that a doctor can be found to have acted unethically, even if it's found that they weren't unlawful.
Thank you, Erin. I think we should, at this point, flip the discussion to the criminal law aspect. I had mentioned earlier that we would be discussing the Beale judgment. Before we discuss its implications, I'd just like to give our audience a very high-level understanding of the matter. So on the 14th of March 2025, the Gauteng High Court acquitted the pediatric surgeon and retired Professor Peter Beale on charges of murder and fraud, bringing finality to the infamous case which has been described as a test for the criminal liability of healthcare professionals. Dr. Beale was charged with murder and fraud, and the fraud charges were based on the allegations that Dr. Beale misrepresented biopsy results in order to take unnecessary procedures. The murder charges arises from surgery-related procedures on 3 distinct occasions, which resulted, unfortunately, in the death of 3 children he operated on between 2012 and 2019. The procedures were allegedly unnecessary and performed with the motive of improving his financial gain and status. Dr. Beale had pleaded not guilty and denied that he made any misrepresentation and that he had not had any intention to commit fraud and generally believed the procedures was necessary under the circumstances. Dr. Beale testified that he had no intention to mislead anyone and that misreading the biopsy results was a human error. In the absence of any contradictory evidence, the court accepted his testimony. He further testified that he had no reasons to conduct the procedures for financial gain, but rather based on the facts and the circumstances of each case. The judgment criticized the state for failing to call expert testimony and found that the state had not been able to prove its case. Considering that the entirety of the state's case was premised on the allegation that the accused performed unnecessary procedures for financial gain, which allegation was disproved by the accused, the state's entire case collapsed. The court found no direct evidence supporting the allegations of murder in any of the rated charges, and the legal principle regarding inference-based reasoning could not support the allegations of murder. Furthermore, the state failed to demonstrate the necessary knowledge of unlawfulness. So, Erin, this matter has been widely publicized, mostly on the basis that the MPA tried convicting Dr. Beale on murder charges. We've already discussed the risk faced by practitioners for civil liability. Can you give us some insights into criminal liability, please?
So, I think the first major difference between criminal liability and civil liability is obviously the burden of proof that needs to be proven. The state in a criminal matter will need to prove its case beyond a reasonable doubt, as opposed to on a civil matter where it's a balance of probabilities. So in the Beale matter, for example, the court specifically noted that it would only be entitled to convict Dr. Beale if it was satisfied not only that his explanation was improbable, but that there was no doubt that that explanation was actually false. And as you say, it's created this media frenzy, and I think the reason why is because the surgeon was charged with 3 counts of murder. And only on one of these counts was the state trying or seeking the competent charge of culpable homicide. So, in other words, what the state is saying is that the doctor intentionally killed his patients, rather than being charged with having negligently killed his patients, which would be a conviction or a charge of culpable homicide. As it currently stands, the threshold in our law to prove that a doctor ought to be held criminally liable for negligent acts is no different to what needs to be proved when, for example, we're trying to hold a motorist liable of driving under the influence, causing an accident, and which then results in the death of a number of road users. So in other words, our law doesn't recognize degrees of negligence when determining the culpability of a healthcare professional. And I say that this is significant because in other jurisdictions, like England or New Zealand, they've actually started shifting this threshold from the low threshold of an ordinary reasonable person to a much higher threshold where the state needs to prove that the accused was grossly negligent or that they acted with complete recklessness. For example, in New Zealand, an accused is charged with the crime of what they refer to as negligent manslaughter. And I think it was in about 2002, the appeal court, the New Zealand appeal court, stated that in order for an accused to be charged with negligent manslaughter, there needs to be a major departure from the standard of care that is expected of a reasonable person in those circumstances. England is similar. So they also have a charge of what is known as manslaughter, and they've specifically formulated that negligence needs to be gross in order to satisfy that threshold in the courts. And their courts have actually stated that if the accused was aware of the risk and decided to take it, then the accused was reckless. But that degree of negligence must be extremely high before the conduct would be considered criminal. And then just one other jurisdiction that I actually find very interesting is in Scotland, where besides having this higher threshold, where you need to show that the accused was extremely reckless, they also want the prosecution to show that by prosecuting the accused, it will be within public interest. So what they do there is they actually have an inquest that is first undertaken to determine whether a healthcare professional should be criminally charged. And it seems that the prosecutor in the inquest, they refer to him as the Lord Advocate. The Lord Advocate has a very wide discretion to determine whether this conduct would be in public interest to charge the practitioner with their culpable homicide equivalent, or whether they would rather proceed with what they do in Scotland, being a fatal accident inquiry. And there they actually then just rather look at the facts, from a point of view of how do we learn from these experiences so that these circumstances don't happen again. So following, I think, these jurisdictions and looking at the latest string of cases that's been in the media and that you referred to earlier, Lucia, for example, that Donnie van der Walt matter where he was found, he was convicted of culpable homicide, and he was sentenced and served time. And it was only after he had successfully applied for parole and after serving time that his conviction was then overturned. or where Dr. Danand, he was charged with murder quite quickly. There wasn't like a long process of investigating or anything before charges of murder were raised against him. So I think because of this, a number of the medical fraternities, actually, including the Medical Protection Society, they've requested the South African Law Reform Commission to review the law of culpable homicide here in South Africa and its application in respect of healthcare practitioners and within a healthcare setting. So the aim of the investigation will then be to consider whether we can then elevate this threshold from what we are using at the moment as ordinary negligence to that of like gross negligence, like I've been referring to in the other jurisdictions. So this request has actually been approved by the Law Reform Commission, and criminal liability of healthcare providers will now be investigated by the Commission together with the South African Medical Association, and they're referring to this as Project 152.
Thanks, Erin. It's very interesting and, of course, always good to see how other jurisdictions are tackling these problems, right? You also then mentioned the inquest system in Scotland. Do you think that South Africa will ever follow a system where an inquest must first be held before we can charge a healthcare practitioner?
As far as I understand it, Lucia, Project 152 is being set up to consider all avenues on how the NPA should approach these types of matters. So one of the suggestions that's been raised is actually to create a special unit where the NPA works together with the HPCSA to investigate these claims at a very early stage, and where they formulate guidelines that they can use to then determine the practitioner's culpability, so that they can consider not only the degree of negligence that might have been displayed by the practitioner, but also to look at the circumstances leading towards the death of the patient, and also whether there's then enough evidence to substantiate the charge that they would then want to bring against the healthcare practitioner.
Thank you, Erin. It's clear that the Medical Association has a lot to consider, especially to ensure that such systems like inquests or even preliminary investigations will work in a South African setting. Before we end off, we've been referring to incidents where it seems that the NPA got the charges wrong, or where they were simply unable to prove their charges. Have there been any incidents where practitioners have legitimately been held accountable for criminal acts?
Yes, I think it's important to bear in mind here that the MPS or the Medical Association, they're not advocating here for a situation where practitioners don't face criminal liability at all. The position will remain that a healthcare practitioner can and should face criminal liability in circumstances where it's permitted. So as examples, I think it's always easier to look at these things when we see a practical setting. I think it was 2019, a doctor had to plead guilty after he was charged with 3 counts of murder in circumstances where he assisted patients in ending their life. There was also another example where a doctor was found guilty of culpable homicide and sentenced to, he was sentenced to jail time, or he was given a fine. But it was after he failed to render appropriate post-operative care to his patient following a liposuction surgery. So there's definitely examples where healthcare practitioners can and will be held liable in those kinds of circumstances. And although it's not criminal in nature, but there's also been a number of examples where doctors have been removed from the healthcare register after disciplinary action from the HPCSA has been instituted, and there's been a disciplinary hearing. Lucia, I'm sure you'll remember the matter of Dr. Luke Gordon. They termed him the butcher of Benoni. He was a plastic surgeon that was found guilty of unprofessional conduct after he had botched plastic surgery procedures. I know in one of the matters, one of the patients, their leg had to be amputated after he did a calf implant. And many of the other complaints was patients where they said that after his surgeries, they had massive scarring and they were actually, it looked deformed. So although I wasn't personally involved in this matter, from the articles, I believe, outside of being deregistered, he had civil claims against him and he paid in excess of 4 million rand in claims to these patients that instituted claims against him.
Lorraine, thank you for that. I think we could continue on this topic for hours, but I'd like to give our audience some time to ask questions. But before we move on to that, do you have any concluding remarks from your side?
Yes, I think the biggest takeaway from these matters is that it's so clear that healthcare practitioners are facing major risks, not only in respect of the decisions that they have to make on a daily basis in terms of, differential diagnosis, what treatment plans they have to take for their patients, very difficult or highly technical surgeries that they have to perform. But now they're also facing this very real risk of being held liable for what might even be just the slightest degree of negligence, And I think in these matters, especially when it's so publicized in the media, we tend to focus on the patients or the victims in these scenarios. But we often lose sight of how this affects the practitioner and the mental anguish and the anxiety that the practitioner must be going through. So we need to also consider their mental well-being. And over and above that, the reputation and how their reputation must suffer when they have these civil claims or criminal claims against them, especially when it's so, so much in the media and so much in our faces. I mean, if a doctor is facing all of this, especially with the insureds that I've also had to deal with, you can see the anxiety that this places on them, that they need to go and continue treating and continue their work every day, and they have this looming thing over their head of potentially being found liable. And I think it creates a situation where doctors need to now start practicing defensive defensive medicine, that they might be sitting there and saying, well, my gut is telling me that this is what I should do, but I'm so nervous of potentially facing any kind of liability that let me rather just take that next test, or let me rather just, take the next step that might not necessarily be warranted or necessary, but I want to double check and I want to make 100% sure that we're correct here. I've also heard of a number of medical professions that just stop practicing, or they've gone overseas to practice where, maybe in Scotland where there's an inquest that will happen first, and then we obviously lose those skills here in South Africa. So it's really something that we also need to, I think, always keep in the back of our minds when dealing with these matters as well, looking at the doctors and their well-being also.
Thank you, Erin. I'm looking at the Q&A box, but it doesn't seem as if we have any questions from the audience. I'd like to maybe pick your brain on the matter for Dr. Beale, where he was then ultimately acquitted. I saw that the court noted where it stated that the state had failed to prove their case also on the basis of a lack of expert opinion. So in your professional view, what is the importance of expert opinion in matters like this, whether it be civil or criminal, to disprove or allegations that's been held against the medical professional?
I mean, expert opinion is essential in matters like this, you know, and as I always say to our insureds as well, you know, we're attorneys, we're judges, we know the law. We don't know the medicine, we don't know the procedures, you know. So of course we will need to get experts that will testify to these to be able to say whether or not a doctor in these circumstances, you know, if we're looking at negligence, whether they acted reasonably under those circumstances. So as I mentioned earlier, what we would do is if it's a GP that we're looking at, we get the opinion of another GP to be able to say to us, you know, yes, they acted reasonably, or no, they did not act reasonably. And I think, you know, experts need to also bear in mind, obviously, that we want them to be objective, and they're there to help the court at the end of the day. They're not on anybody's side, you know. There's no question of the plaintiff's attorney appointed you or the defendant's attorney appointed you, and so you must act as a plaintiff or as a defendant. They're there to serve an objective role and to assist the court in not only understanding the procedures, but also in determining whether or not these circumstances permit the charges that are imposed against the practitioner.
For sure. Thank you for your insights. Any other remarks from your side before we conclude our session this morning?
No, not from my side. Thank you, Lisha.
Thank you, Erin. Thanks so much for joining us today. I think that this session has definitely highlighted the importance of healthcare practitioners themselves having to have a greater understanding of medical malpractice, and particularly medical negligence leading to both civil and criminal liability, as well as possible consequences of an HPCSA inquiry. Medical practitioners are therefore encouraged to reach out to the brokers in assisting to secure the appropriate cover through that iTOO may have available if they are faced with civil criminal liability. This is particularly important for practitioners who are not just starting out, but also for those in specialized fields. The need for medical malpractice insurance is particularly necessary when the practitioner is slightly more inexperienced, or where they are dealing daily with highly technical and difficult cases. So from my side, thank you to everyone who's joined on the call. I trust that you have a great rest of the day of Tuesday, that you stay home. Thank you, Erin, once again for joining us. And we'll see you next time. Thank you so much.
Thank you so much. Thank you, everyone.
Thank you. Thanks, everyone. Bye-bye.